Okay, let's talk a few minutes about negligence theories, liability, not negligence, but liability theories, one of which being negligence, another one being strict liability. Those are sort of the bookends. Uh, Basic negligence theory says that I need to be reasonable, and we are looking for the ever evasive reasonable person, right? And that's the basic idea behind negligence, is that we set a standard that says there's a norm in the community, and whatever that norm is, that reasonableness norm, that's what we aspire to. And we hold people responsible for consequences when they breach the norm. And so, for instance, in a car accident case, which is the most prominent variety in the United States of these kind of events, somebody is going too fast for the circumstances. They, blow the stop sign, or they blow the red light, that kind of thing. We have determined in advance those things are unreasonable. Sometimes they're unreasonable because they violate the law, and we sort of automatically say, hey, look, if you run the red light, you breach the traffic laws, and we just sort of deem that unreasonable. But we further believe it's unreasonable because people ought to pay attention, right? And they ought to be careful when they're driving around. The same thing could apply if you're, in your yard and you are using a weed eater and you get near something of your neighbor's and the weed eater tears it down. Maybe your neighbor has a set of flowers that are particularly important to them, and you get over there with your weed eater and you're just not watching, and you look away to see something, and and you just weed eat them right away. Well, that's a problem, right? And again, you weren't being careful, you weren't being appropriately reasonable, and so we say that's negligence. And if you've caused an injury and you have a breach of your duty, right, the duty to behave reasonably, and you, in fact, that breach of duty caused the injury, and then there are damages that follow from the injury, then you can be held responsible. Basic negligence theory. So that's over here. Over here we have strict liability, right? Strict liability says, look, if you engage in an activity and the result of the activity is that someone is injured and that injury causes damages, right, then you are responsible, regardless of how much care you have put into the situation. Typically, we reserve strict liability for instances where we believe there's an inherently dangerous activity. Now, why do we do that? Well, theoretically, the reason we do that is because we want to preemptorily cause people to concern themselves when they are going to engage in highly dangerous activities, such as blasting, which is the prototypical example used in torts textbooks. And so we have those two kind of ideas. Okay, strict liability over here, right? Hey, you're doing something that we're just going to hold you responsible for it because you're engaged in the activity. You've done it, and if something ensues, you need to take care of it. Negligence, on the other hand, says as long as you act reasonably, we're not going to hold you responsible because we don't feel that that's appropriate, and we want to promote the activity, and so we don't want to hold people, strictly responsible, because if we do, there'll be less of the activity. And you can see how this tends to work itself out. And one of the things that I want you to think about as you are responding to me on this is how does this all impact us as a society? I mean, it does matter. These things do matter, obviously. If you just go with a strict liability standard all the time, that when everybody engages in any kind of action, if it causes a harm to someone else, they're automatically responsible, regardless of the care. Economically speaking, there's going to be a likelihood that you get less of the activity. I mean, that just makes sense, particularly for people who are very risk averse, and even people who aren't super risk averse, but who are, there's a marginal point at which people who are fairly risk averse are going to stop doing the activity, and maybe you don't want to do that. For instance, automobile driving. Whether we like it, don't like it, and that's for another day and another class. So whether you think cars ought to be allowed, and all the issues that we deal with automobiles, the fact remains the American economy depends on automobiles. I mean, it really does. And if we had a strict liability regimen where everybody who got in a car was automatically responsible for what happened, no matter how cautious they were, and no matter how reasonable they were behaving, we'd have less people driving, and it would also likely, I would expect, shoot up insurance rates, and then we'd have a problem there. And so that would create some really interesting difficulties, perhaps. This is what I want you to think about when we're talking about liability theory. These are the kind of issues I want you to grapple with. Now, let me say a couple other things before I finish about contributory negligence and comparative negligence, which fit into liability theory schemes when we're talking about negligence. If you have a negligence basis for the activity, whatever it might be, and obviously one of the things, and let me throw this out there, you want to think about is, well, where do you want strict liability and where do you want negligence? And is there a time when you want one or the other? And are there certain activities that you want to deem, like we do, in fact, deem are okay for negligence theory versus strict liability theory? Do you want a combination, or do you just want to go one way or the other? If you go with negligence theory on in any place or any instance of an action that somebody's engaged in, then you've got to start thinking about, well, what do you do when both parties maybe have some responsibility? But in other words, we look to that evasive, reasonable person, right? And we find that neither party is completely free here from sin, if as it were, right? They've both got some culpability. How do we deal with that? One way to deal with it is what is known as contributory negligence. If you are responsible at all, you lose. There are many out there who think this is just horrible. Now, as a practitioner of many years who was practicing in Virginia, where there is what's called pure contributory negligence, what I found, quite frankly, was that juries were very good at sorting this out. They did not hammer somebody because they were a little bit negligent. They just didn't do it. The idea that somehow, well, somebody's 1% negligent, they lose, that's great law school fodder, and it's interesting in law school exams. But when your feet hit the streets, when the rubber hits the road, when push comes to shove, I'm trying to think as many cliches as I can quickly, that doesn't really work. Juries, they sort through that, okay? And in my experience, juries, if they felt like somebody, maybe they were a little bit negligent, yeah, they weren't completely reasonable, but what they did was they made what we would refer to as a causation analysis, and they basically decided, yeah, they were a little bit negligent, but it really didn't cause the accident. Let me give you a good for instance. You've got someone who blows a red light and goes through an intersection and hits somebody. The person who's going through the intersection who gets hit is speeding. They're going 30 and a 25. Okay? Technically speaking, that person, even if injured, ought to receive a goose egg, right? Because they're negligent, and if you're in a pure contrib circumstance, they ought to just lose. But that's not how it works. That said, that's the technicality of it, and you have to weigh that. And there certainly some jurors might say, no, hey, they were negligent, they lose. That's the way it is. It's black and white, man. And you have to deal with that, and that's possible in a pure contrib situation. The other situation you have is what's called comparative fault and comparative negligence. And in comparative, as the idea suggests, you just compare the fault of the parties and you reward them accordingly, and they get awards accordingly. There are two versions of this pure comparative, which is, hey, somebody's 90% at fault, they can still sue you for the 10%. I've not dealt with that very often, and my suspicion is that most jurors would treat that the same way they treat pure contrib. In other words, they would say, if it's 90-10, we're not giving the 10 guy, we're not giving the 90 guy who's 90% at fault, we're not giving him anything. That'd be my guess, because that's just how juries behave, in my experience. You then have, so if you've got the person who has the 10%, who has the 90% fault, you're in trouble. Okay. Now, where jurors decide to draw the line, I don't know. Some states have that. Kentucky, where I live right now, has pure comparative. Other states, like Indiana, which I live next door to, where I'm in Louisville, and right across the Ohio River is Indiana. Indiana has what's called has a comparative negligence where you have to be at least 50% at fault before you have to be less than, sorry, 50% at fault before you can make a claim. And so that's another way to do it. And again, you could even, and there's nothing that would stop you, you could even decide that there are times in certain circumstances when one kind of liability theory makes more sense than another kind. And you could, do what we do. And as most states in the United States have a variety of circumstances in which we pick and choose which areas we like. And we accordingly decide that we want to, in effect, we want to have certain activities engaged in more and some engaged in less, and by setting the liability standard, that's part of what we're doing.